Hello, we're here at Litigation Fundamentals with Henry Quillian at Taylor English Duma in Atlanta. And today we have a great presentation put on by one of my colleagues, John Rezac, who I'll introduce in a moment, regarding the impact of bankruptcy on litigation. And he will address quite a number of issues. There's no way to cover them all, of course, with respect to how bankruptcy can impact litigation throughout the course of litigation and after litigation, I'm sure. As we all know, we are here at Taylor English with a number of our colleagues. We're here to discuss issues and to try to learn as much as we can. For those out there in the world, we're not providing legal advice. We're providing issues that you can look into with your own lawyer and also to discuss or research yourself. And of course, we're not encouraging anybody that's not a lawyer to practice law. Well, many times throughout the course of my litigation practice, we have experienced the impact of bankruptcy on litigation. Obviously, the most straightforward would be you get a judgment and the other side files bankruptcy and you don't collect. But there are many other confounding things that can happen because of the bankruptcy laws that impact all sorts of things in connection with litigation. So I asked John Rezac, who is one of my partners here at Taylor English, who has 20 years of bankruptcy experience, mainly in the commercial realm, mainly representing creditors, but sometimes representing debtors, to come discuss with us here at Taylor English and also with you out there on the web, the impact of bankruptcy on litigation. John actually worked after going to Lemoyne College in the financial services industry, both at a big firm and a smaller financial services firm. And then he went to Georgia State University to get his law degree approximately 20 years ago. Since that time, he's worked at 2 international law firms, and he's been at Taylor English for quite a number of years. How many total?
6.5.
6.5 years. Almost the exact same amount of time I've been here. And I think he's prepared a great presentation. I worked with John a lot on matters, sometimes hair-pulling ones, and I know he's a great lawyer. So, John, you can come up and tell us about bankruptcy.
Thank you.
Thank you.
Thanks, Henry, and thanks everybody for being here. Bankruptcy issues, bankruptcy law intersect with litigation all the time. In fact, the very day that Henry asked me if I'd be willing to do this presentation, Craig came into my office and asked a question that basically sets up the type of stuff we'll be discussing today. They were suing somebody who was threatening bankruptcy, and he had the question: what happens? What do we do? What impact it's going to have on our claims? And it's probably one of the most enjoyable parts of working here is that bankruptcy is really just a set of procedures. There is a particular venue, but as far as the substantive areas of law, it covers everything and anything. And frequently matters come to me because you all are representing someone in litigation or you're pre-litigation, and bankruptcy comes up and we get to work together on it. Henry mentioned one of the more common scenarios where you get a judgment against a defendant, and somewhere in the course of enforcing the judgment, the defendant files for bankruptcy, and that's kind of the easy one. And we'll talk a little bit about that. Basically, there's a claim that can be filed in the bankruptcy court, and some litigation, considerable litigation, can go on in bankruptcy. But probably the biggest single element of bankruptcy law that impacts litigators is the automatic stay, and it's under Section 362 of the Bankruptcy Code. The automatic stay is in place to benefit the debtor. I'll be referring to the debtor as the company or the person who is filing for bankruptcy. And the automatic stay gives them a little bit of breathing room while they try to reorganize, or while a trustee tries to administer an estate and liquidate assets. It also benefits other creditors because it prohibits one creditor from rushing at the debtor. It discourages those races to the courthouse. The automatic stay operates as a stay, and this is from the statute, applicable to all entities of the commencement or continuation, including the issuance of employment of process of a judicial, administrative, or other action or proceeding against the debtor that could have been commenced before the bankruptcy case, or to recover on claims that arose before the bankruptcy case. So that's typically we're talking about filing a lawsuit or continuing a lawsuit. So you've already sued the defendant, he goes and files for bankruptcy, and you've got your process server driving around trying to serve them. You know, those things have to stop. Discovery and things of that nature that may be pending are stopped. The automatic stay also prohibits the enforcement against the debtor or against property of the estate of a judgment obtained before the commencement of the bankruptcy case. It prohibits any act to obtain possession of property of the estate or of property from the estate. I'll talk a little bit about that. Or to exercise control over property of the estate. So it's very broad in its scope. There are some exceptions to the automatic stay. Certain things that are not impacted by it. For the sake of this discussion, pretty much anything you're going to be trying to do to someone or some company that files for bankruptcy, pre-bankruptcy, is going to be stayed once they file.
John, does the stay exist even if the creditor, the one that's chasing after the person that becomes a debtor, doesn't know about it?
Yeah, absolutely. I think if you read my outline, it is automatic in nature. When a debtor files for bankruptcy, there is a list of creditors that is typically included. It's not always included, and so notice may not go out immediately. So in some cases, it doesn't go out at all. But the automatic stay is automatic, and it is effective whether I know that you have filed for bankruptcy or not.
So what sort of notice would somebody have to get to legitimately stop an activity they're doing? For instance, they're levying on the house that day, and the debtor comes out in their underwear and says, "Hey, I filed bankruptcy." Does the sheriff have to stop immediately? And what happens if the debtor then sells the house to somebody else and they didn't in fact file bankruptcy?
Answer the second question first. That's a risk that's going to have to be taken, and my advice to a client would be you're going to have to take that risk rather than run the risk of contempt of the bankruptcy court. If the debtor gives any notice that a bankruptcy has been filed, it needs to be taken seriously. The bankruptcy courts are all online, so in a matter of minutes, you could bring up the bankruptcy court dockets across the country and verify if the debtor has filed. As a note of caution, it is possible that a debtor could file a paper pleading and that will not automatically appear online. So calls to the clerk asking the debtor to provide a copy of the bankruptcy petition would be a good idea. Even if the debtor says, or the person who claims to be the debtor says, I don't have it, to produce to you, and you're not finding anything online, I would still be very reluctant to go ahead and conduct a foreclosure, or take any action against the debtor or the debtor's property if there's some indication that a bankruptcy case has been filed. That does open up open up the opportunity for abuse by folks who just say, I filed bankruptcy when they haven't. But the bankruptcy court takes very seriously the automatic stay and expects that everybody else do as well.
What if they say I'm bankrupt?
I would go through the same, bankrupt. I don't know that his that may be a sort of a slang, use, an inartful use of the term. It may not mean they filed for bankruptcy. It may just mean I don't have any money. I'm bankrupt. I would go through the same due diligence before I told my client go forward with whatever action it is we're talking about. The reason for that is because there are serious consequences for violating the automatic stay. And you have two potential violations. One is unwillful and the other is willful. And Henry's question goes to that distinction. Frequently, a debtor will file for bankruptcy not on the eve of foreclosure, but the very morning of foreclosure. Here in Georgia, our foreclosures begin at 10 o'clock a.m. on the first Tuesday of the month. The debtor could go in and file bankruptcy at 9 o'clock, and the attorney representing the foreclosing bank has no knowledge of it. That will not be, if the foreclosure goes forward, that's not going to be looked at as a willful violation of the automatic stay. The foreclosure will be void. It will be of no effect. Anything done in violation of the automatic stay is void, not voidable, but it's void. Different situation when the bank or the creditor, the attorney representing the creditor, has some knowledge of the automatic stay. The scenario that Henry presented where a debtor says, "I'm bankrupt," that puts me on some kind of notice. Perhaps I go forward with the foreclosure only after I do this due diligence and cannot find anything to support the debtor's claim that he filed for bankruptcy. I think in that case, a judge after the fact might say, well, you did foreclose and there was a bankruptcy, but you made a good faith effort to confirm it and reasonably concluded that there was not a bankruptcy. So we're not going to hold you in contempt of court. We're not going to impose sanctions on you. However, your bankruptcy, or your foreclosure rather, is of no effect. Much different story if I know of the bankruptcy. I get a copy of the petition with the bankruptcy court's docket indication on the top of the petition, and I know that the bankruptcy case is pending, and I go and take some action. And that may be something active. I conduct a foreclosure. I repossess a piece of equipment. It may be a bit more passive than that. Last week I repossessed your fleet of trucks. And today you file for bankruptcy and you demand that I return the trucks to you. The automatic stay prohibits my exercise of control over property of the bankruptcy estate. And just holding on to those things would constitute that kind of exercise of control. That's the situation where creditors frequently get themselves in trouble. There are options, there are alternatives for the creditors to pursue. So in other words, someone who's gone through the effort and expense of recapturing collateral may not want to turn that over to a debtor, but would be well advised to get in front of the bankruptcy judge immediately and seek relief from the automatic stay. There is a provision in the bankruptcy code for getting relief from the automatic stay to either do something or to validate something that was done without knowledge of the filing of the bankruptcy. And typically it's a creditor who's looking to conduct a foreclosure or a repossession of some sort. But often, as we've already discussed, it could be a situation where I've conducted this foreclosure with no knowledge that my borrower has filed for bankruptcy. It is possible to go to the bankruptcy court and explain sufficient circumstances where the court will give me relief from the automatic stay retroactive to the foreclosure or to the notice of foreclosure, however far back is necessary to validate the action I've taken. That's the exception, though. Typically, the bankruptcy court is going to want to give the debtor the full benefit of the bankruptcy code. So anything that was done after the bankruptcy case was filed is going to be undone, and the creditor gets in line with the other creditors and can assert its rights in the bankruptcy case. Just a kind of review on some of the things that are stayed by the automatic stay: filing a suit, service of process, recording of a judgment, conducting discovery. Frequently, these things are already in process when a defendant goes and files for bankruptcy. And occasionally there is some action that has to be taken by the non-debtor party or his counsel. So a good example is in the case of garnishments. Might file a garnishment to serve it on the bank, and the judgment debtor files for bankruptcy. I've got some obligation to the court, the state court, to put them on notice of the bankruptcy case. And we often see that also in the course of litigation, where one party will file for bankruptcy, and perhaps a defendant files for bankruptcy. That stays any claims against the defendant, but it technically does not stay counterclaims by the defendant against the plaintiff. So you have the potential for a real unfair situation. Typically, state court judges or non-bankruptcy judges are going to stay the whole proceeding once they hear the word bankruptcy. But in the event that you are representing a party in bankruptcy and somebody else, some other party files, what do you do? Any thoughts? What obligations would you have as the non-debtor party to the court? I think anyone I've worked with, and I've always taken the position that even if it's not my client filing bankruptcy, I want to let the state court judge know. So there is a suggestion of bankruptcy that can be filed, and it's a simple document that's filed. It says, here's the party who filed, here's where they filed for bankruptcy, and the case information. But it also can be used as an opportunity to educate the state court judge. We've used it particularly in situations where we've got multiple defendants, and one defendant files for bankruptcy, but the others don't. The automatic stay only impacts the claims against the bankrupt defendant. The others often will try to take advantage of the automatic stay, but as plaintiffs' counsel, we will put the state court on notice of the case and also use it as an opportunity to let the state court judge know that this case can otherwise proceed against the other defendants. We see we should talk about what the automatic stay stops. It does not stop actions against co-defendants who have not filed for bankruptcy. It doesn't stop claims or actions against spouses who haven't filed, or principals of a corporation that has filed for bankruptcy. And so one useful tool of the suggestion of bankruptcy that is filed with the state court is to make sure the state court judge knows that the rest of the state court action can go forward. It's usually a good opportunity to ask the state court judge for a status conference as well, just to make sure you are not delayed unnecessarily in that action.
John, is a document called a suggestion of bankruptcy really just a notice to the court?
Correct.
So it sounds complicated, but it's not really.
That's right. It's very. It's nothing more than a notice. And again, the issue of who should do it. I think there's a strong argument that the lawyer representing the party who filed for bankruptcy really has the obligation to let the state court know. Frequently, they won't. And again, I think it's an obligation as an officer of the court, and as an attorney for any party to the litigation, to advise a state court judge of something like the filing of bankruptcy by another party. And also it keeps you in the judge's good graces. We did have a situation where a judge pulled a bunch of resources to render a decision on, fortunately, another party's motion for summary judgment, and found out a couple months later about the bankruptcy case, and the judge was pretty unhappy about it. So it's a good idea to make sure that you keep the state court judge informed. Once you're in bankruptcy, it's it's important to make sure that that you're getting the notices, and you file an appearance in the bankruptcy case. Make sure that the clerk of court provides notice to you. It's crucial in bankruptcy because there are a number of deadlines to file claims in the case. In Chapter 11 cases, there will be a plan of reorganization, and you have certain times by which you can object to that or participate in the plan of reorganization process. So at the earliest opportunity, it's wise to file an appearance in the case and make sure that you're getting all the information necessary to advise your clients. If you represent the debtor, the party who has filed for bankruptcy, one thing that is frequently overlooked is getting bankruptcy court approval of the professionals that represent the debtor. So that would be the debtor's bankruptcy counsel, special counsel, and accountants, appraisers, and things of that nature. Usually the lawyer who files the bankruptcy case is going to know enough to file an application for his approval. But frequently there's special counsel, perhaps the lawyer who was handling the state court action, who's going to continue to have some role, or accountants, appraisers, things of that nature. The importance of getting approval of your employment is because the bankruptcy code wants to make sure there's full disclosure of who is representing the debtor, make sure that there are no conflicts of interest, and it's a higher standard than what lawyers typically look at just when they're assessing conflicts of interest in order to represent a party generally. There are consequences of not getting approval. In the Middle District, there is a rule that no attorney's fees are going to be permitted for any work done prior to the application for approval. And as bankruptcy cases are so front-loaded, there is a tremendous amount of activity at the beginning of the case. And there have been instances where a lawyer has neglected to file his application for employment until a couple months into the case and finds out he's worked for free for a couple months. The law is that approval of payment is required even if payment is coming from some other party. I don't know, I have not seen an instance where a bankruptcy court denies a lawyer's fees and some other party comes in subsequently and pays them. But I wouldn't want to be the lawyer who has to explain that to a judge after the fact. So the rules require approval of the employment of professionals, so do it. Back to the issue of state court litigation, we've got a common issue when a bankruptcy case is filed is its impact on the statutes of limitation. And bankruptcy case will toll those statutes, so in the instance where you have not yet sued your defendant, the bankruptcy case typically will toll any statutes of limitation until the bankruptcy case is, usually it's when the bankruptcy case is closed. Actually, 30 days after notice of the termination or the expiration of the stay under Section 362. So 30 days after the automatic stay is terminated. Now there are other things there are other ways that the automatic stay can be terminated. For instance, the confirmation of a Chapter 11 debtor's plan of reorganization, or if I were to file a motion for relief from stay with the court asking for permission to go back to state court and continue litigating, in those instances you need to be aware that you've got 30-day clock. So if you've got a statute of limitation that has not expired at the time that the bankruptcy case is filed, you will have until the later of the expiration of that time or 30 days after the termination of the automatic stay. There's tolling also with respect to claims that the debtor might file. And usually with those claims, we're talking about claims that a trustee in bankruptcy is going to be filing. Did you agree?
I did have a question. Does that tolling act in any way as an extension of the statute of limitations if the debtor has gone through a bankruptcy during the course of time that between the time the debt arose, for instance, by the creditor against the debtor and the time that the creditor ultimately brings the action? If the debtor goes through bankruptcy and there's no discharge, does the creditor have more time, let's say than 6 years, to file an action if it was a written contract debt?
If the creditor will have until the later of 30 days after the automatic stay stops or the natural termination. So if for some reason the debtor was in bankruptcy for 5 years, you don't tack on a full 5 years to the statute of limitation. You've got, in that case, you most likely have 30 days after the automatic stay is terminated.
John, can I ask a question?
Yes.
You mentioned relief from stay. I don't know if you're going to get into that, but what are the general grounds for getting relief from stay? When should a lawyer think, oh, well, I might be able to apply for relief from stay rather than just taking a hands-off consultation of bankruptcy?
John's question was, what are the grounds for getting relief from the automatic stay? There are essentially two sections of the statute that address that. One has to do with acts against property of the debtor. Usually we talk about a foreclosure. With that, the creditor, the movant who's asking for relief from stay, needs to show that there's no equity in the property and that the property is not necessary for an effective reorganization. So if it's a Chapter 7 case, you don't have the issue of reorganization, but you still would need to show that there's no equity. The reason for that is if there is equity in the property, that equity might be liquidated and used for distributions to other creditors. With respect to anything, whether acts against property of the estate or lawsuits, assertion of claims, there is a for-cause standard. That cause might be lack of adequate protection of the movant's interest in property. More often than not, it's presented as a balancing of the equities. So you might have a lawsuit where the debtor is one of 12 defendants, and there might just be no practical way to dispose of the claims in that litigation without other than getting relief from the automatic stay in the bankruptcy court and having everybody stay over in the state court. The bankruptcy judges have considerable discretion to weigh those things, but the code says for cause. It does not define what cause means, but a review of relevant case law would give the attorney some indication of whether cause is present under the facts of that particular case. Once in bankruptcy, so relief from stay is one way to ask the bankruptcy court, let me continue to go forward with my state court claims. Another option would be to remove the state court action to the bankruptcy court under the federal statutes. That frequently isn't even required. That might be more than is necessary to get to the creditor's objective. In all bankruptcy cases, a creditor has an opportunity to file a proof of claim. So if I'm suing the defendant for a $100,000 breach of contract claim and the defendant files for bankruptcy, I can file my proof of claim for $100,000, attach the necessary backup documentation. That proof of claim is going to be prima facie valid unless and until somebody objects to it. Often in a Chapter 7 case, a trustee is appointed, and the trustee might look at the supporting documentation and think the claim looks right, I'm not going to object to it. That creditor would then have an allowed claim in the bankruptcy case of $100,000. The distribution on the claim is a whole other issue. That comes if and when there are assets available for distribution to creditors, but the necessity for prolonged litigation on this breach of contract claim goes away because an independent, objective trustee looks at the information and says there should never been, a lawsuit. There's no benefit to the estate for me to fight this creditor. They've got an allowed claim. If in the event that there is an objection, the trustee objects, or in a Chapter 11 case where the debtor stays in control of its assets, the debtor might object to a proof of claim. That litigation can take place within the bankruptcy court, often more efficiently than it would be outside of bankruptcy. So the necessity of stay relief, so I can go back to state court, or removing that state court action to the federal court is usually not necessary. The bankruptcy code gives a mechanism for those claims to be resolved.
Does a party in litigation with bankrupt entity lose its right to a jury trial if it's removed to the bankruptcy court?
Very good question. Not automatically. There are certain actions that can be taken by a creditor, by a plaintiff, in the bankruptcy court. For instance, the filing of a proof of claim, whereby the creditor subjects itself to the equitable jurisdiction of the bankruptcy code in the bankruptcy court. When that happens, the creditor gives up the right to the state court right to a jury trial, or any right to a jury trial, because there are not jury trials in bankruptcy court typically. There are circumstances when the creditor still retains the right to a jury trial. The bankruptcy court can handle the litigation up to the point of the trial itself, at which point the litigation is handed off to the district court. There's been a considerable amount of law in the past 10 years dealing with issues of jurisdiction, subject matter jurisdiction, and whether certain claims can even be disposed of in the bankruptcy court or need to be sent over to the district court. Much bigger discussion than we had at this lunchtime or others, but the right to a jury trial can be waived by certain actions taken in bankruptcy. Mark?
When you're talking about subject matter jurisdiction, are you talking about in the bankruptcy court or in the district court that it gets sent over to?
In the bankruptcy court.
What about the district court? What if you have two Georgia parties with a breach of contract for $20,000? The district court wouldn't normally have jurisdiction over that matter. Or do they have jurisdiction by virtue of it being in bankruptcy? I don't know.